Good to see old and new people. Although you are young, right? So, and after a long time, so good evening, everyone. So I had stopped teaching AD classes, and means I guess last time it can be 2020, and then because of
2020.
yes,
Some classes in 2020 on online.
so in 21. So COVID crisis and other things, health factor. This otherwise I used to take most of the classes, means almost 80% of the classes in AD. We started in 2013 AD classes, and it was used to be, let's say, quite popular ones, and many students, let's say, find attending those classes also. Anyhow, let's take without wasting time. I'll use black screen, right, because of online visibility. This so basics. First, we should understand about electoral bond, which you may be familiar, and then we'll talk why what Supreme Court gives judgment on that. So. These are, although it is written, isn't it? It is my habit to write all these things. So this before we start, let me curiosity test your knowledge. Which will give understanding how better you know. It is very simple question. Right. So C option, clear, good awareness. This D. I will not tell anything. Yes, all five. Cash is not. It is enough. Das. 20,000. Right. Just basic questions. Good questions will you will see in Pansutra. AIPMT. Yes. So good awareness level. Some you have, but where it matters when question comes related to understanding, there it will be challenge. Like second question. I will still not tell the answer. I will talk towards it. Yes. So you may be familiar with electoral bond, isn't it? So it was introduced through Finance Act, isn't it? Yes. So this Finance Act brought four major amendments, this, which we relate to. First, this section 29C of Representation of People Act, then section 13A of Income Tax Act. It is given, you can see this, section 31 of RBI Act, and section Companies Act. So by these amendments, they try to implement this, what we say, electoral bonds. Electoral bond scheme you can consider this. So under section 29C, it says that political parties, means political parties receiving those electoral bond related funds detail, they don't have to maintain that records. This, so though they don't have to maintain records and they don't have to disclose it, those records they don't have to disclose. This same thing related to 13A, let's say that they are not expected to maintain the records like those electoral bonds, and they are not, let's say that expected to disclose it. This, and it is in this section you'll find this they have mentioned also how it will be paid. What should be the mode of payment? It is also mentioned. This. So both acts are related, changes are related to disclosure. It is related to disclosure, and disclosure is not, let's say it is, disclosure is barred. This. This. So generally when they get funds, so they have to disclose to Election Commission, including, let's say, that the identity of the person and other details. This 20,000 above. The funds they receive, they have to disclose to the Election Commission. But under, let's say, under this scheme, by amending the two sections, they have added that they are not supposed to maintain the records and also disclose to Election Commission. This. So this is related to disclosure aspect. So it is promoting kind of secrecy. Yes. And this is the main concern, let's say. It is the main concern, secrecy as the main concern. Then in RBI Act, they amended that government can authorize any such, let's say, banks for issuing of such, let's say, that bonds. Right. Generally, it is RBI which is the authority, although government can also be. But by amending Section 31, it authorizes government to empower any such bank to issue those bonds. This government, and government basically empowered the State Bank of India. But it is not a problem in, let's say, that overall legal challenge. RBI amendment has not been a major challenge, let's say. Then this section, it, let's say, that brings, it removes the cap. There used to be 7.5% cap. This, that any company which wants to fund political party, it can fund 7.5% of last 3 years profits. This, and by amending Section 182, this capping is removed. So it means, let's say, that any company can fund to any limit. In unlimited manner. This, it can fund to political party. And then company also does not have to maintain in its, let's say, that record that which party it funded. It has to just maintain the record that this, it bought electoral bond, it funded, let's say, it gave political funding. This, but it does not have to mention in its record about also details of the, because it is a bearer bond. In bearer bond, it is not mentioned. The identity is not disclosed. This. So Section 13A, 29C, 182, they are the main challenge in this, let's say, that when it is challenged. This. Now let's keep political parties. Political parties, then banks, and then those, let's say, bonds, and then buyer. It can be of different denomination. This. So any such buyer can buy, let's say, that you buy this. So any buyer, let's say Mr. X buys this one such bond. So in this bond, let's say Mr. X wants to, let's say, give fund to, we can mention, let's say A, B, C, D. This. So, Mr. X wants to fund to a particular political party. This. So, he can buy it, and the bank will, let's say that deposit that, suppose he wants to buy for this political party A. So he buys this 1 crore, let's say, bond, and the bank will deposit in that party A. That party A will not know about identity of X. This. So it will not know that which party Mr. X has given. Sorry, let's say that which person has given to party. This. Same thing happened with other such buyers. Now, but banks will have the details. Bank knows. The bank will know the no identity. Because the person who is buying is KYC compliant. So when person or any, let's say, person or company means entity, it does not distinguish, which later on will tell that. So when Mr. X buys any such bond, and then let's say it is for a particular party, he will buy the bond for related to that party, or let's say bank will deposit in that party account, and the party will not come to know that which person has deposited, means which person has funded. Bank will know about those who are buyers, and bank will keep itself the identities. As per the amendment, let's say various such, let's say, sections, bank will not disclose the identity, but on certain, let's say that grounds, bank can disclose identity to certain authorities. This. Right. It can be, yes. Yes. Right. So there are, let's say, two specific such that if it is needed on some special grounds, or if there is any criminal case. If there is any criminal case, in that you need to know the details, so then the bank can disclose. Means there is no absolute, let's say that guarantee for non-disclosure. This. But it is not also the main concern. It is also not the main concern. Let's understand the positive side. What is the positive side of the electoral bond? How government says that it promotes transparency. That is also important to understand. So basically what happens that since you have to deposit or you have to buy only through check online, means since it will be non-cash payment, any such non-cash payment is being presumed as transparency and elimination of black money. Because black money we are presuming is something, let's say that it is called cash payment. The cash we are presuming has black money, and online payment has white money. Right? Although it may not be the right definition. Right? Because cash can also be white money. Right? 10 years back cash was white money also. अभी तो digital payment अभी शुरू हुआ है. Right? Anyhow, but since it is a KYC compliant and non-cash payment, so we think that cash is largely taken as black money, so it will eliminate any such practice of cash payment. There will be online, let's say, transaction. So when there is online transactions, it is a clean transaction we consider. This is one. Second thing is that since identity of the buyer is not known, so then government is saying that it will give a level playing field to political parties. This, because if, let's say, as per the principle, not practice. Why it will level playing field? Because buyer's identity is not known. So when identity is not known, then people will also fund to opposition parties. This, That's why, let's say, Arun Jaitley ji, when he is giving a speech in parliament, looking towards the opposition, he says कि आपके भी फंड में पैसा आता रहेगा. This is how he says. मतलब जनरली रूलिंग पार्टी के टाइम पे अपोजिशन पार्टी के फंड में पैसा नहीं आता है. उसका इनडायरेक्ट कहने का ये भी मतलब है. बट उन्होंने ये बोला कि हमारी सरकार ने बिग हार्ट दिखाया है. राइट, इट हैज शोन बिग हार्ट and now in your accounts also money would keep coming. This, if we go as per the what is written in law, that way identity is not disclosed, so people will, let's say, be willing to fund to any political party. This, so these are the two, let's say, that you can consider advantages of this, let's say, new funding system or electoral bond. But the same, let's say, apply the concerns, what happens, how it promotes more opaqueness rather than transparency. This first thing is that this State Bank of India, the State Bank of India itself comes under Ministry of Finance. This, and let's say that we know the given the practicality, let's say that given the prevailing condition in our system, right, can we say that Ministry of Finance is so sacrosanct it would not ask details of those who are giving the funds? This, so you can yourself judge it. This, and when they have given riders in some, let's say, conditions, it can disclose to appropriate authority. So then this is how, let's say, that it results. This, and the bearer bonds will have tracking system, let's say that. There will be a tracking system, a technicality is told. So that tracking, because of that tracking system, the bank records, when they are maintained and submitted to the government will anyway come to know. The bearer instrument that they are, let's say, issuing, and their tracking system they will have. So anyway, government would come to know. This is one. Second, before interim order, if you see 2019, the before interim order, if you see in this, your backside, it is given graph in this. Yes, this. Before interim order, right? Interim order means in 2019 Supreme Court gave order. What order it gave? You have to disclose details about the funds to Election Commission of India in a sealed cover. This sealed envelope. That is how sealed cover nowadays. Right. The Supreme Court gave this order that you have to disclose to Election Commission of India. The Finance Act and the amendments barred such disclosure. They don't have to give to Election Commission of India. When it was challenged, so Supreme Court passed an interim order. And when it passes an interim order, you know what happens? This interim order has resulted into sharp decline of this funding to a particular political party.
Was retrospective in nature, or was it to be applied after the?
Right. It should be, let's say that he may not, let's say, have to focus on that aspect. They passed an interim order, you disclose to Election Commission. This, it may be retrospective. It may be retrospective. That's why details have been given. Let's say that details. Now let's say thereafter, let's say other political parties also getting some funds. This. So it shows, let's say, it itself shows, the graph itself shows the challenge. Challenge you can say, or opaqueness we can consider in the system. Right. But that is not the problem. Problem is, let's say that a serious problem is this. Suppose we generally give an example. Let's say there is a political party. Let's what we can say that M and company. Let's say Y. And it is in government, let's say, and it gives favor to this company. And in that favor, let's say that company has to give favor to this, and company decides to give, let's say that, this much favor. Right. So it is quite easy to give, let's say, 1,000 favor to that party through electoral bond. This. It is quite easy, because this, what it will do is that simply it will buy this one or any such, let's say, that instrument, and the fund will go to the political party. This. And on its account detail, company detail, it will be written as that it has been gone to the political funding. It has been gone to the political funding, but in actual practice, it is not for political funding. It is a kind of favor given. This. It is a kind of favor given. This. The only thing is that it is being paid online, digital mode. And we may not understand this, distinguish between that, whether it is, let's say that you want to fund, that's why you are funding, or you want to give a favor, that's why, let's say that you are funding. So even it is quite easy by electoral bonds that companies can give favor to the political parties, especially the ruling party, whichever the party, ruling party, and that will be more as a corporate favor rather than political funding. And electoral bond will not be able to eliminate it. This. So without going in legality, because court will look more into legality. Right. We are here giving more example in terms of substance. Right. The court has examined the legality. We are giving this example of a substance. Substance aspect is that it will promote more opaqueness rather than, let's say that transparency. And it will give preference, let's say, when secrecy is maintained, it gives more preference to the ruling party rather than to the opposition party. It does not create, it does not play, you can consider, level playing field. This. Transparency means level playing field. It should, let's say, bring level playing field. This. And because of that, let's say that time RBI also gave its dissent view on that. It was not also in favor. If you read details, the RBI raised concerns, and it sent its concerns to the government. Ministry replied, and it was very, let's say that brutal to RBI. This. The reply, if you read details of the judgment, in that it is given. Ministry is very brutal to RBI. How can you say that it will not promote transparency? This. Anyhow, right. The government retorted to RBI concern. Similarly, let's say Election Commission of India also raised its concern related to electoral bond, and that concern also government replied defending its transparency. This. However, since we have taught from the very beginning, at, let's say when it was introduced, at that time we have taught it. So that time government replied in Parliament that RBI and Election Commission both supported electoral bond. This is to know that. On the floor of the House, the Finance Minister told that they have not registered this. In actual practice, now it is very clear, they registered. Right. Yes. Then you should know that this in 2019 Election Commission itself filed an affidavit in Supreme Court. This in 2019 Election Commission also files an affidavit in Supreme Court, right, against this bond and raises its concerns, right. This and then when electoral bond was introduced, that time itself uh, this ADR, which is common, you know that ADR and Common Cause and let's say Communist Party of India, the three petitioners, they challenge its constitutional validity. They themselves had moved to the court, let's say that. Plus, in 2019, Supreme Court files an affidavit. They challenges basically the constitutional validity of electoral bond. This let's take that what they challenge. This first thing is that they have challenged under Article 32. Yes. Yes. The petition has been filed under Article, let's say, this called Article 32. This. By the way, PILs are filed under Article 32. That it is challenged by petitioners. This. What is the challenge? Constitutional validity. That what constitutional validity? This. Basically, they bring RTI. This. It is related to, let's say that undue influence. Undue corporate influence basically means it affects free and fair election. This. Then privacy. Privacy is linked to Kutta Swami case. This. Hence, basic code. Before code, there are, let's say that 3-4 questions. One is whether constitutional, constitutional, So they go more in legality aspect, and their main concerns are related to this. So whether amendments means all those amendments are constitutional. If they are arbitrary to such, let's say that the provisions of the constitution, so they will be declared as unconstitutional. This then in that details, let's say that they go in details of this, whether it means whether amendments violate 19(1)(a), then whether it violates Article 14, and then privacy wala matter that will tell, and then finally it is related to corporate wala, right, section 182, and whether it affects free and fair elections, and whether free and fair elections, right, free and fair elections of, let's say, considered as foundation of democracy, blah blah things they will try to link, right, and on the basis of that they have tried to pass their judgment. Now when they pass their judgment, so they will try to analyze. Basically this is nothing but if you are able to take decision, if we are able to take decision on this, so that will itself will result in this. So basically there are, let's say that three questions in this legal challenge. One is related to Article 19(1)(a), then it is related to equality, then it is related to this privacy, should we maintain privacy, and then it is related to whether there is undue influence, free and fair elections. This means we can tell that the four issues, let's say, in fact the four issues that they have. And on those grounds, let's see what they are trying to say. Let's take one by one. So (19)(1)(a). So we know that Article 19(1)(a), it has given, it is the basis for right to information. Already you know the background about right to information. This and this right to information, so it relates to, it has evolved over those cases. Cases are related to this Rajnarayan case, SP Gupta case, SP Gupta case. Then there are two more cases, ADR and let's say People Union of Civil Liberty. Right. In these cases also court has told that this voters have right to know the antecedent of candidates, basically they are trying to weigh down, let's right to know on the one hand. On the other hand, political parties to maintain secrecy, and donors to maintain secrecy and privacy. This relationship. So on the one hand, Article 19(1)(a) promotes, let's say, freedom of information in democracy. Already, if you know, if you have studied RTI, so you know that how RTI is considered as part of Article 19(1)(a). This, in democracy, citizens have right to know. That right to know was also first time highlighted by SP Gupta case. So SP Gupta case is also mentioned when we talk about RTI, how RTI evolved. This, in democracy, citizens have right to know, and that right to know, let's say in elections, let's say when political parties, they are saying that political parties, they should maintain secrecy, or they should not disclose details, or they are not supposed to disclose the details about those who have given the funds to Election Commission of India. This, so it is, let's say, maintaining secrecy. So whether maintaining secrecy plus their privacy and secrecy, whether both can override right to know under Article 19(1)(a), or they violate Article 19(1)(a). This, the court has tried to review, if you see, the court has tried to review all those cases. It will review cases related to right to know, plus freedom of expression, Ramesh Thapar case, Indian Express case, blah blah things will find us. Similarly, SP Gupta case, Raj Narayan case, other cases. Similarly, they have reiterated when, let's say, recent developments have happened, where, let's say, voters have the right to know, about the candidates, their details of information. So when voters have right to know even about the candidates, their antecedents and others, then why, let's say, that they will not know about those who are funding political parties? This, why they should not know those who are funding political parties? This, and similarly, political parties, they have seen other set of judgment in which they say that the political parties are the main instrument of democracy. They are trying to link political parties and again freedom of expression. The freedom of expression is part of democracy, and democracy is because of political parties. So when political parties are maintaining confidentiality or secrecy, it is affecting democracy. So on the basis of the relationship between, let's say, that these three, they have given preference to this over this. And then they say that the amendments, let's say section 13A and 29C and section 182 of the Companies Act, they violate Article 19(1)(a). This, that is how it is, first part of this first aspect of the judgment. This is how they say this, and that is how we can write on this.
Why do political parties want to maintain secrecy? Why are we considering that as an aspect?
Yes, they have said that if we disclose details of the identity about those who fund, especially corporate, so there can be public reaction, or let's say people may have, they can see that in a very different way. Or they say that there can be public outcry or public, let's say that means people will think it in a that corporate, they are giving favor to corporate. This, not crony capitalism. They say that since people in our country lack greater awareness and other aspects, so when people will come to know about corporate funding, so then let's say people will view it in a different way. Right? Not that it is a necessity to fund in elections. This means electorates are not, let's say, electorates still lack judgment, means wisdom to have a more objective view of the funding rather than subjective view of the funding. That was the logic given. Yes, the government will know. That is how we have told in the analysis. We have told that, but court will not go what we are telling. Court will see the laws that you have brought in. What we have told is the essence, you can say, essence aspect, analysis aspect. But courts will have to see the amendments that you have brought and what you are trying to say on those amendments, and then what they have given past judgments. Basically, courts will see the legality. The court is trying to see the legality. Legality is what? That when you say that a political party should not disclose it, so why it should not disclose it? Now you justify it. So they will ask legal questions. Hey, why you should maintain secrecy? Right, in a democracy, when even you have given right to voters to know about the candidates. Right. If a candidate has a criminal background, if a candidate has assets, what are the assets a candidate has? This you are telling that these are all you have to mention in your election affidavit when a candidate goes to file nomination. In that affidavit, the candidate has to mention all details. In fact, the court has gone beyond that also. Right. Same common cause case and other cases, you know that after Lily Thomas, the court has gone into saying this. You maintain a website and even you give details that why you have given a ticket to a criminal background candidate. So on the one hand, courts have gone to talk transparency to a very high level. On the other, here let's say that you are not, let's say that simply disclosing that who are giving the funds, and plus those who are giving the funds, donors, their privacy is also maintained. This, so when this privacy is maintained, so on the, let's say that when we promote transparency, our citizens, let's say that citizens should in democracy exercise their democratic rights, right to vote on the basis of right to know. After all, let's say this is how election commission and all these, let's say that awareness we create. What? You should exercise your right to vote, informed right to vote, let's say that. You should get information, you should get, let's say that awareness, so that you can exercise your right to vote in informed manner. This, so when you say right to vote in an informed manner, so it also includes that which, let's say that persons are, let's say entities are funding to which political party. This, it is in that sense. That is how the court gives logic, and that basis they say that it is violative of Article 19(1)(a). Here we'll highlight one thing. When government has given secrecy and this confidentiality, so petitioners have argued that Article 19(1)(a) is barred by, or reasonable restriction is imposed only by Article 19 Clause 2. Right? Now, whatever the reasons they have given, those reasons do not fall in the category of Article 19 Clause 2. This, so on that ground also, let's say the court means that cognizance has also been taken by the court. This, because reasonable restriction on freedom of expression is by Article 19 Clause 2, and the grounds on which you are trying to maintain secrecy here and here, they do not come in that category of Article 19 Clause 2. This, so that cognizance is also taken, and that is how it has been told. Like this, let's take this equality aspect. How it violates equality. This. Yes, anonymity can also be considered. Anonymity clause you can bring in, privacy clause when will take. But you can say that it is transparency and anonymity. This. Yes.
सर वो आप कह रहे थे कि मतलब एनोनिमिटी रखना चाहिए, वो इसलिए कि क्योंकि वो कांग्रेस जो है ना, मतलब कांग्रेस पार्टी, उसको अगर कोई देता है तो अगर उसको मान लो कोई गवर्नमेंट को जो बीजेपी उसको दे देगी, अगर उसको पता चल जाएगा इसने दिया कांग्रेस को फंडिंग वगैरह.
No, we have to rise above that. Equality clause, let's say. So democracy, that if you read DD Basu, तो पहले ही कुछ पेजेस में ये लिखा है कि इक्वालिटी इज एसेंस ऑफ डेमोक्रेसी. Equality is essence of democracy. This, because any democracy is based on equality. Democracy है तो equality ही होगा. Right. This. Now, how it violates equality principle? This. So let's take that called violation of free and fair election. Free and fair elections. Right. And free and fair election is based on equality. How? One person, one vote. Right. So when you have one person, one vote, it is equality. Right? So otherwise, privileged class can have 2-3 votes also. Right. This one person, one vote का मतलब क्या होता है? Equal influence by all. Unless there is equal influence by all, there cannot be free and fair elections. This is the principle. For free and fair election, each that voter that you have, they should have equal influence. This, otherwise, their vote has no meaning. This, if there is undue influence. Now, this is supported by political theory before going to judgment, given by very old John Locke. उस समय फंडिंग का नहीं था, but he talked about this followed by John, another John Rawls. This, in their political theory, they have dwelt, you can say that, in details about elections, let's say, means democracy, in democracy about the influence. So basically, they have been saying that equal influence. Each citizen should means person should have equal influence, and then there can be free and fair election. And again, free and fair election is one such fundamental aspect of democracy. This you can consider. And you should know that it is because of this principle that we can consider difficult to get, but more than, I will say that more than 50% countries, right, follow this. Some countries have even banned corporate funding. They have banned corporate funding to maintain this. Because they think that as long as there is corporate funding, there cannot be equal influence. Or more and more corporate funding means less equal influence, and less equal influence means lack of free and fair elections. This is how they are saying, like. Now, how Supreme Court has applied this principle? The Supreme Court applies this way. When capping has been reduced, capping has been removed 7.5%. This. So now there will be corporate influence because they can fund to any limit. This means they can fund to any extent. This. Second thing is donor secrecy. Donor secrecy has been maintained. Third is that the way denominations are, let's say in electoral bond scheme, the way denominations have been mentioned, 1 crore. 1 crore kaun dega? This. So the way it has been designed, it suits to more of corporate funding. This is how it is more inclined towards corporate. Then they will go and invoke various types of judgments in past given where they will try to establish a link between corporate influence, let's say that black money and politics, let's say that nexus they will try to establish how there is a, let's say, link between, let's say, political parties and corporate. And one reference also they have given of, you will be happy to know. This. So it is a prelim question also. Yes. Which will show in your coming test. Because one question they ask from administration. The UPSC has developed this habit of asking a question, although it is not necessary, but yes. Now let's take that what they are saying. Santanam committee recommended in 64 how there was corporate influence in election, and it was one such basis for corruption, because Santanam committee was set up on corruption. This, so they have given reference in the judgment. They have given reference of Santanam committee. So basically, there is a nexus. There is a close nexus between political parties and corporate, and then corporate gets undue. Let's say that this influence through funding, and that influence through funding will affect this one person, one vote, or it will affect equality, right? Since it will affect free and fair elections. And on this ground, they have told that this the amendments violate Article 14. So basically, here they will say this. It will be related to section this 182 of Companies Act. This amendment is violative of Article 14. And that is how, let's say, they say that enough to tell unconstitutional. It is enough to tell unconstitutional, but let's take other question that we have written. This we have proved, and privacy, whether they can maintain privacy. यहीं से clear हो गया कि they cannot maintain privacy, but we'll come to this. And whether undue influence, it is clear they have undue influence, right? Now can they maintain privacy? Means this, can we maintain privacy? Means donors' privacy can we maintain? This. Donors' privacy. So, you know that they have invoked Puttaswamy case. Right. It is legality, legitimacy, and proportionality. Then protection to privacy. Government says that why don't corporates should not disclose their identity. It says that it is they have privacy right. This. So when they have privacy right, then the privacy right comes under article. And when it comes under article 21 privacy right, so then let's say ki Putta Swami case, he told that ki privacy can be maintained. We can maintain privacy on the basis of the three conditions when met. This three conditions means that these should be backed by law. If you want to promote privacy of any, let's say, persons, it should be backed by a law. So that law wala part qualifies. They're trying to bring law. Yes. Then legitimacy, court से also चलो मान लेते हैं legitimacy भी है. Because you want to address black money. So you have a legitimate cause. Right. But court says that proportionality. This proportionality factor is violated. Right. How it is violated? So they have brought, let's say that one, this arbitrary clause. This perceived arbitrariness. This they say that it is perceived arbitrariness. Basically, that kind of arbitrariness means ki they have such kind of term defined in past judgments. Let's say Shaira Bano judgment, Nautej Singh judgment. This. So there, let's say ki they have invoked, let's say, perceived arbitrariness clause. Means ki when you are trying to bring any such law, so the law may not clearly, let's say, ki be arbitrary, but it appears to be arbitrary. This. So when let's say donors are being given, let's say, ki privacy, ki they will not disclose their identity. So complete, let's say that ki barring their identity appears to be arbitrary. This. And there is no any, let's say ki, we can say that proportionality means a give and take type of relationship. If some of the rights are restricted in return of something. Right. Proportionality clause was brought in context of Aadhaar. So let's say ki Aadhaar and privacy right. So in that case, the court, let's say, did not strike Aadhaar violating privacy right by saying that ki by Aadhaar you are getting benefit. Let's say service, let's say government service delivery. Under government service delivery, you are receiving benefits. What you are receiving benefits? Clean service delivery. The Aadhaar is a tool of good governance, court went on saying, and says that it delivers clean service. And in lieu of, in return of clean service, you can compromise your right to privacy. This is called proportionality. You receive something and you compromise something. But in this case, there is no proportionality. This. Rather, it is arbitrary because you are not losing anything, you are not compromising anything. When secrecy of donors are maintained, so they are not compromising anything. Rather, it benefits them. This. And when they are contributing to political parties, so court says, contributing to political parties will amount to, let's say that, public nature of activity. Political funding to political party will amount to public type of function. Now how it brings? Another past judgment. BCCI वाला भी judgment उन्होंने invoke किया है. Right. So you should know that they have given past judgments in which they have told that BCCI The BCCI is not a public institution, but it performs public function. This similarly, funding to political party is in public nature. This you need to understand. Funding to political party is not, let's say, commercial. Funding to political party is public nature. And since it is public nature, you cannot have complete privacy. This, therefore, they have invoked so many cases related to this arbitrary clause, even unrelated cases. Let's say Shaira Bano case यहाँ क्यों आएगा? Right. So triple talaq case. So Shaira Bano case, let's say they have brought. So in Puttaswamy, let's say, in addition to Puttaswamy, they have brought also Cricket Association case, BCCI case, Shaira Bano case, and others. And they have tried to link कि how, let's say, that कि maintaining privacy is arbitrary, and it fails to qualify proportionality. And on this ground, this is how they, let's say, that they have considered the amendment. Basically, they consider the first three, let's say, amendments 29C, 13A, and 182 as violation of 19(1)A and Article 14, and separately Section 182 of Companies Act is violation of this Puttaswamy. This, and that is how, let's say, that ki Puttaswamy plus, as we have told, that equality aspect, right? And these are, let's say, that ki legal aspect of the judgment. This, if you see, we have given summary also 2 points. It is written. It is page number 10, if you see that. In summary, bench passed judgment that amendment this violation of Article 19(1)A and this amendment violation of Article 14. That is the takeaway. Like, if you take something concrete takeaway, this is how the takeaway you can say this. So, are you able to understand what the technical aspect? Right. So, there are 4 amendments in Finance Act. Right. This. Before we take your question, let me give. If you take timeline. So basically, it starts with 2016. This, which is also part of the challenge, which we have not considered. 2017, 2019, and finally 2023. I will not go into this aspect. It starts with 2016 Finance Act. Finance Act amended Foreign Contribution Regulation Act. This, under Foreign Contribution Regulation Act, you should know that in 1976, when Foreign Contribution Regulation Act was brought, so that law was to bar any political funding by foreign entities. This, it bars foreign political funding. But by this Finance Act, this 2016, foreign funding was allowed, provided any foreign company has majority equity shareholding in any company in India. Right. So they will treat that company like Indian company, and then it can have political funding. Now, it is again, let's say, they have, let's say that brought under that corporate analysis itself, not separate analysis they have given. They have given analysis as corporate undue influence on free and fair election. Within that, they have incorporated this also. But you should know that the law which barred political funding is indirectly giving political funding. And it is unfettered because there is no regulation. And if you remember, Foreign Contribution Regulation Act, how it is very strictly enforced on civil society organizations. They are allowed to maintain one account in State Bank of India only in Delhi. But there is no any regulation on political parties in lieu of when there is foreign funding this to political parties. This is one. Finally, let's see the Finance Act. It introduced those 4 amendments. And it was challenged, and this is called interim order. Supreme Court gave interim order. As we told that कि disclosing. In between चलता रहा उनके बीच आपस में. Right. This court was not trying to that कि here petitioners file at least 3 times for urgent hearing. And before this hearing, the last time they warned the petitioners that don't force us for hearing that case. This. But finally, when election coming close, again petitioner went. Now election is coming very near, it is an important case. Then finally they agreed to hear this case. This. Now, इसका जो दूसरा पार्ट है इस केस का, वो अभी तो इसमें है ही नहीं. उस पे जब जजमेंट आएगा तो ये ऑटोमेटिकली अनकॉन्स्टिट्यूशनल हो जाए. What is that? It is a finance bill. It is a money bill. Right. Passed as money bill. Passed as money bill, the Rajya Sabha is bypassed. Now it is under challenge. वो एक separate story है. Right. So money bill, whether let's say money bill, it is at larger bench, 7-judge bench or 9-judge bench, you know that. This, it is not only this wala, let's say that related to this quasi judicial body restructuring bill. Roger Matthew case, Madras Bar Association case, 2021. This, so that Roger Matthew and Madras Bar Association case related to quasi judicial body restructuring bill 2021, that has also been sent to larger bench, and it has also been sent to the court ने ये बोला कि देखो already जो money bill वाला matter है, it is to larger bench. So we will not go into this aspect. We will hear only the second part, whether the amendments are violative of Article 19(1)(a) and this and that. This, and that is how they have gone into logicking and saying that they are arbitrary, and that is how it passes that it is unconstitutional. This, right? Yes, now you can ask. Yes?
Just want to ask about the money bill.
Yes. So any other question? What you want? Right. Let it be again challenged. Right. That was not a right judgment. I will tell that. PM Care Fund is a public trust. Government cannot constitute public trust. This you should know that. Second, after all, funds in PM Care comes from government. PSUs, salary, etc. Let's say that. This plus PM is the head of the level. Other cabinet members are the members. How it was created? This, but Bobdet साहब थे उस समय. So let's see if you talk as per the legal aspect. So legally it is not a public fund. If you go for more critical aspect, let's say. But let's see, court at times also, you know that they pass their judgments. So we'll go by that. Yes.
So now we follow the system that we followed before 2017 for donations.
Yes, now government will, you know that, government will certainly respond. Right. Government has been, yes, what had it?
The recent response, they have said that they respect the mandate and their intention was only to cover that. So they respect the mandate.
Right. Basically, let's say that then we have to see what is the, let's say what are the let's say that things left, let's say that, or what options government has, or what it can do after amendment. Since in summary, let's say they have declared it unconstitutional, entire Finance Act sections. So there is no any scope for bringing change or amendment like Election Commission of India Condition of Service Act. Right. So Election Commission, that they removed Chief Justice and they brought the selection committee. So because of that, let's say that in this there is a very less scope that you go and amend it, because it is, let's say in summary, let's say at macro level they are striking corporate influence. So now there is no scope to you can amend it. You have to show their identity. This they will have to show their identity. This plus in interim order itself it told that you disclose to Election Commission of India, and now it has passed order that you have to disclose all. It has told to State Bank of India that give all the details of the funding to Election Commission of India, and then it has specifically also mentioned that Election Commission of India should made it public. This अब कोर्ट को स्टे करने के लिए, कोर्ट के जजमेंट को स्टे करने के लिए जैसे कि ऑर्डिनेंस लाया था उन्होंने, तो वैसा कुछ पॉसिबिलिटी है नहीं. दिस बिकॉज इट हैज बीन ब्रॉट बाय फाइनेंस एक्ट डिक्लेयरिंग एज मनी बिल. This, so let's say there is no, we do not see that the government will try to amend it. So now we will go by, yes, we will go by what were the practices we had before introduction of election, this electoral bonds. This then question comes that how we can promote clean practice. So again it brings the debate on state funding of election. Means again you go back to the same debate. Now it gives a strong basis for, yes, it gives a strong basis for political parties to be brought under RTI. This you can consider. This is one aspect you can consider. Second aspect is that let's say Supreme Election Commission of India in 2022 gave one, let's say that memorandum to the government, in which it has asked the government to introduce a reform that you cap the total cash funding to 20% of political funding to a political party. Means a political party should not receive more than 20% of its total funding as cash, this or in cash, or either 20% or 20 crore. This either 20 crore you receive, because the cash that you receive, which is should be, let's say 2000 and less, cash can be, means cash funding can be done 2000 or less. So that cash funding should be either 20% of your total funding or 20 crore. This, so that also, let's say, will become more, means again debatable. Because if you see, read ADR report, according to ADR report, it is a bit old, let's say till 2014, thereafter I have not seen, certainly report may have come, but ADR has said that 39% of the total political funding right, come through undisclosed sources. This, so that 20,000 class that you have, 20,000 and let's say you should not disclose, that debate will also come. Means now the debate will come on reforming your, let's say, system, electoral system, funding system, where we can have greater transparency. Right. Transparency in the sense that 20% or 20 crore clause, means let's give reference. And second is that why, let's say 20,000 or less, you should not give details. Rather you should, let's say that any non-cash, any non-cash political funding, you should give details to Election Commission. Yes. So that can be, let's say, key aspect. There will be debate on, let's say, improving, you can consider as transparency in political funding. Then it brings again the debate on state funding of election, which is very old. This, or how we can promote better practices, clean practices. This, already you may be aware, it is old topic, outdated topic. But anyhow, topic gets evolved and new nature starts coming. This, right, someone is saying, will fund given through electoral bond will be given back. Right. I guess you may be beneficiary. Right. This, that you can consider. Right. Right. Anyhow, वो nitty-gritty details they have given कि अभी जो नियरेस्ट ड्यूरेशन का जो है रिसेंट फंडिंग जो होगा उसका उन्होंने डिटेल दिया है कि आपको रिटर्न करना है नहीं करना है. यू कैन रीड इट, इट इज माइनर एस्पेक्ट. दिस basically state funding if you highlight, but there should be a separate class on state funding because, but just I will summarize it. So do you think that any committee who, it is also a very simple question, which of the following committees has recommended for complete state funding of elections? No. Right. No committee has recommended. Right. Although law commission once in, after Indrajit Gupta, law commission is given. It recommended, it is desirable, let's say that, although it supported Indrajit Gupta committee. It starts with Indrajit Gupta committee, you know that, whether we should have it state funding of election or not. Blah, blah, it goes to, let's say, RC second also, law commission also. Law commission, then now, let's say that, now, as of now, if you see this. So, there is a fact given if you read. This on page number 16, on top page if you see. This is how this fact was, I was trying, although it is again old fact, but it is 2012, you know that, but by this time further things may have changed. What it says, see, 86% European countries, 71% Africa, 63% America, 58% Asia. They have somehow, let's say that, state funding. This we can consider. In state funding also, let's say basically Germany model is popular. It is Germany, Canada, a bit of given, let's say that on this. Germany, Canada, they have state funding. France also has state funding, although it is mixed type. US and UK, they follow, let's say that, more corporate funding rather than the state funding. But they try to maintain transparency. This. There are some countries, Brazil, South Africa, there, let's say, this is how they give more emphasis on state funding, and this is how I was saying, on the ground of equal, let's say, influence of, let's say that voters, means all should have equal, let's say that influence. Anyhow, state funding is, state funding or funding of political parties should not be linked to just black money. Then it will become a narrow debate. This you should know that. Funding of elections should be centered to this equal influence of all. This. And this will promote free and fair elections. If it is just focusing on black money elimination, then you will try to address, let's say, influence of only corporate aspect, let's say this, rather than promoting, let's say, greater, let's say, dispersal of funding in elections. State funding cannot be completely, means we cannot have complete state funding. This should also. If you have complete state funding, so then you have to bar private funding. But all private fundings are not arbitrary. This you should know. All private fundings are not arbitrary. Let's say your relative is in election, so you can support. Right. Those people know that person, they can support. This, our public spirited individuals can support. So why we should bar, let's say, any such private funding? This is how focus is on corporate black money wala part. As long as your focus is on black money part, your debate will be narrow. Rather, our focus should be on funding of elections so that we can minimize undue influence and, let's say, promote each voter should have equal influence, although it is difficult to achieve. Right. Political funding has been a serious challenge in Western democracies, not only in our country. This, in US also there was once a scam. In, let's say, that UK also once there was a scam. So maybe next time we'll bring any topic related to, I can talk in details. This, but this is what we'll find, that they have also faced challenges, and that's how they have been trying to move towards different modes of funding. This, in our country, debate has not, let's say, that gone to a level you can talk something. Once there was a debate, and in that debate, Yogendra Yadav versus ASY Qureshi, that debate also happened. The Yogendra Yadav supported complete funding of, let's say, elections, and ASY Qureshi, who was ex-chief election commissioner, he rejected complete funding of election. So ऐसा नहीं कि debate नहीं हुआ है, past में debates हुए हैं, but those debates have not reached to a certain level, you can say this. And then again, time to time, we just keeping like this. In those debates, one idea which can be, let's say, that considered viable is called, that is called National Election Fund. This, it is called National Election Fund. We can create a national election fund at national level, and all those people, let's say, they can, anyone can fund to that national election fund. This, anyone can fund to National Election Fund. Now, it will be kept by Election Commission of India, and then on the basis of percentage of votes received, this, by political parties. So basically, state funding of elections should be, it is state funding of political party, not elections. This, state funding of political parties, and in that political parties there should be conditions, percentage of votes received, and after election on the basis of percentage received, though this is how their expenditure would be reimbursed by this national, let's say, that election fund. That debate has also been brought, but let's say that it is who will do all these things basically. Clean practice.
State funding are two different things. Public funding of elections and state funding of elections are two different things.
Yes, public funding means people are funding, let's say that. This, although in generic sense you can interchangeably use, but public has a different connotation, state has a different connotation. This, although public is also state, but public is also public. Common masses. Public has two connotations, but the state has only one meaning. It is related to the state, means government. But let's say that public, so it can be public means state also, it can be common masses also. This. So this National Election Fund will be of public funding. This, people will fund it. This way we can say. It is also not considered big. It can be 5,000, let's say, crore, or it can be, let's say that it can be 5,000 to even 10,000 crore. Still, it will be less than, The expenditure, you know that the kind of expenditure political parties have in elections. Yes. And it is very huge, let's say that expenditure. And when there is a huge expenditure, so you know that then you have to have also return on those expenditure, especially to corporate sector which promotes crony capitalism, or this is how we can say money, muscle, and we can say media, such kind of influence. The elections will not remain free and fair. So as of now, let's say way forward can be more related to this called state funding, let's say state funding of political party, constitution of national election fund. This can be tried. There should be greater transparency in political funding in terms of that cash funding, right, and financial disclosure. That aspect we can consider. Then there should be greater internal party democracy. Political parties, they should maintain their accounts. Those accounts should be properly audited, and those audits should be disclosed. That aspect can be considered. So this you can say. Plus we can bring other electoral reforms which related to criminalization of politics. That aspect we can consider. So other electoral reforms, including even simultaneous holding of election, the feasibility of simultaneous holding of elections, those things. Plus in general, let's say that there should be greater transparency, which is not related directly. There should be greater transparency in relation to politics and corporate relationship, especially the, let's say that contractual things. There should be greater transparency in contracts, projects that we give, and accountability mechanism which is part of your regulation. If you will introduce that place, because favors are given in that way. The favors are given in that way, contracts and projects. If you bring there also more, let's say, transparency and accountability, as we talk about integrity pact, blah blah things. So let's say those things, let's say also discourage. It means you have to create an overall ecosystem. There should be overall ecosystem. This is how S.Y. Qureshi was trying to talk. He says that state funding will not succeed. The flaws of this is that the day you will have this state funding, you will have more and more political parties. Already you have 500 political parties. In those 500 political parties, some parties are shell companies. Their role is simply to transfer money from this to that. They are just channel of transferring money. So political parties regulation also important. That way we can consider. More importantly, let's say that all these things will happen only when right, political morality. Right. If there is political morality, these problems will not happen at all. Either you bring morality, no legality needed, itself it will minimize. By the time political morality improves, this is how these measures can be brought. And we can cite some examples of those countries once they also faced the problems. Be it Germany, you can say, Canada, you can say, even France also you can say that. US and UK, since they have better ecosystem. The difference will be that they have better ecosystem. Since they have better ecosystem, there will be greater transparency in financial transactions. If we are overall able to reduce corporate influence in policy, let's say decisions of the government, and let's say minimize nexus, at the same time contain black money, they would also indirectly influence clean political funding. That is how it should be talked. Right. So they're saying to repeat the question. Halaki, we have not told any facts related to questions. So prelims related approach is a different. This analysis is more related to the mains orientation. That's why for prelims orientation, wait for some more questions. By the way, this question, C is correct. This, it is either Lok Sabha or Legislative Assembly. Yes. That way you can consider. Others, I guess, others already we have answered. Yes. Although, yes, simple questions. We used to take main questions also at sector in our ED discussion. There was a time, but simple, let's say that. They may have taken from this. The recent Supreme Court ruling on electoral bond is a vaccine for the future, not medicine for present. What does it mean?
Protect us from harm that can happen from that, but it is not giving any solution to what is the problem.
Yes, means this is how we remain in a vacuum. This is how, after the judgment, the vacuum continues. How political funding should be done.
So in the future that there can be political funding reforms.
Yes. This information about funding of political parties is essential for effective exercise of choice of vote. Yes, that is how you can bring that clause. We were talking free and fair election, and yes, this aspect. There is need for effective regulation of political. Yes, bringing about effective financial reform is required. Political will. Yes, the demands. Let's say that it demands political will in the sense that when you have to bring any policy change, it has a political cost. Since it has a political cost, that's why let's say that political will is needed. Because political parties are not, let's say that ready to sacrifice their political benefits. That way we can say, and that is how let's say that Bahujan Samajwadi Party, if you see that. So when there was 20,000 factor, so Bahujan Samajwadi Party disclosed that all its political funds were below 20,000. And when government introduced 2,000 as cash, it disclosed that all its funds belong to below 2,000. So I say that चिल्लर दिया है क्या लोगों ने कॉइन में 10 रुपया 2 रुपया. So that is what we can consider. So let's